All right, people, I am live and I'm a bit early. So I am just going to wait a few, let people know that the live is going on. Let them jump in and join me. I need to mute one of my phones. How is everyone? Let me adjust the angle. This is the first live I'm doing without tech support, although I will say that I had some help from a very kind friend. You know who you are. Thank you so much. That was greatly appreciated. A little last minute, but let me just put this other phone on silent as best I can. Tech is definitely not really my thing these days, it would seem. There we go. So, tonight's topic promises to be one that's a bit of a hot button issue, and it's going to touch on beneficial ownership, complex structures, regulatory requirements, and the other issues. And some of those other issues, you might guess, does involve what is really topical right now, which is sanctions and sanctions compliance. It's real life. This is what we are facing as compliance professionals, whether you are a regulator or a compliance professional. So it's not quite 7, so I haven't gone into my usual welcome as yet. I'm still waiting for people to join. The chat is open, so feel free to drop your comments in, and I'm definitely looking forward to the engagement. So, yeah, why this topic? So, quickly, I can say that this topic was actually inspired by one of my subscribers to the channel. And so, if there is a topic that you want covered, you can definitely ask for a particular topic that is of interest to you, and I will definitely dive in. So, it's not quite 7 yet. I'm still waiting for some people to jump in. And yeah, one of the things I would want, though, and I'm going to repeat this during the session today, is an indication of where in the world you are viewing from. Even if it is that you're viewing after the fact, definitely drop it in the comments below. Reach out to me. There are lots of ways to connect with me, and you can find those in any of the other YouTube videos that I've put out. So, I do know that time is essential. It is now 7 p.m. AST, and so I am happy to begin. And let me just start off by saying, hello, friends, hello, professionals, and welcome back to my channel, The Sea of Regulation. Simone here, and I want to just start off by saying thank you to everyone who has stuck with me. Some of you may have had a bit of insight as to what was going on with me personally. You'll notice the background is a bit different. I am coming to you live from my home. So I do not have the tech support of Pink Mako in Anguilla, but big shout out to Pink Mako in Anguilla. If you have any audiovisual needs, this is not a sponsored promo, but definitely check them out if you're in Anguilla and you have any AV needs. They are definitely the company to go to. And so the patience, thank you so much for the patience, because I came back to the BVI in December. Things kind of got off the rails. And I just want to say I love you guys. Thank you for the patience, to the existing subscribers and the new subscribers, to all the newbies. Thank you, thank you, thank you. I am definitely looking forward to interacting with all of you. I am definitely looking forward to expanding this platform, and definitely want to say that, there's a lot in store. And yeah, let's go on this journey together. So, as I was alluding to before 7 o'clock, this topic was actually inspired by someone who is a subscriber. They asked about, I think it was under my video with TCSPs, about complex structures, beneficial ownership issues. And so I said, well, okay, sounds like a good topic. And it was in the works for a little while. And how long of a little while? I would venture to say maybe 3 months. So that was how long ago the comment was. And then I started looking into delivering the content from about the end of December. And if anyone wants to just jump on and let me know how my audio is coming through, that'll be greatly appreciated. The mic is a little low. Maybe I need to bring it up a bit. There we go. These things happen on a live. Yeah, I'm getting an indication that it's better. So what happens with beneficial ownership? So of course I have my notes, and let me just say this with the notes early on. For everyone who is interested, there's going to be a very short summary of the notes that is provided for free, a PDF document. For the members of Chasing Compliance, which is my membership site, there will be a fuller document that's provided to members for free. So just to let you know that these things are definitely going to give you more than maybe what you expect in some other forums. I want to make sure that that is something that everyone gets from when they engage with me. It's always better to give more than is expected. So some free PDFs, again, for the members, and then there will be some other material that's going to be provided, but I'll get into that a little bit below. But before I get a little sidetracked, there's a lot to talk about. Let me get my usual disclaimers out of the way. I am a financial services regulator. I am not a lawyer, and I'm not a professional advisor. And the views on this channel are definitely on my own and do not reflect the views of any international standard setter or regulatory authority. Now, with that out of the way, let's dive in. Now, guys, I actually had a poll done and posted on LinkedIn on my page for Ignis Solutions Limited. If you don't follow Ignis yet, please go over there and do so. If you haven't voted in the poll, please go over there and do so. There's still time to do that. But I gave some options in terms of what people may have thought were the most pertinent issues in relation to beneficial ownership and analyzing the complexity of it. And from the engagement with just everyone, either on the poll or outside of the poll, some of the things came up as being more important, one of which was AML compliance and risk management. But sanctions compliance, which is topical, also came up. The other option that you could select from was taxation and other. Now, the other was there to generate comments. And of course, if it is that you had a comment in relation to something else that you saw as being critical to why persons need to understand complex structures and why compliance professionals should approach it with caution or what they should do, definitely drop it in the comments below. So, as an overview, one of the things that I wanted to look at was why was it important to determine the beneficial ownership of a structure? So whether it is a standalone entity or a legal arrangement. Now, part of the issue in terms of determining beneficial ownership is to find out who's the natural person that is ultimately the owner and in some instances the controller of a particular structure. And one of the things that you want to be minded of is that corporate structures and legal arrangements can definitely get very complex. Taking a very simple case with a company, you would want to be looking at that first tier of ownership. So in a simple ownership structure, there's only one tier of ownership. Certainly, it can be natural persons and not. It could be another corporate entity or a trust. But if you have a simple structure, it's pretty easy to go up and determine who the natural persons are that are controlling that particular vehicle and who's behind it. So again, one of the things that is important to understand is that you're carrying out these things to ensure that you know who controls the entity, to ensure that criminals, sanctioned persons, sanctioned entities, terrorists, they are not permitted to use legal structures and legal arrangements. And of course, why would we want to do that? Because we want to make sure markets are fair and clear and that you reduce and eliminate where possible, because criminals are innovative. reduce and eliminate financial crimes, terrorism, sanctions busting, and the list goes on. But when you look at that immediate ownership, it can be complex, and it's not just compliance officers that have to do this. In cases when an entity is regulated, regulators have to carry out the same checks. So it's not just the compliance professionals that are in the hot seat. So what else could you consider from this? Well, the information helps to inform several other aspects of how you apply your compliance measures, and we'll go over some of those later. Now, when we're looking at complex structures, you might ask, well, what are some of the challenges that they bring? Well, consider this. That straightforward structure that I mentioned, directly held at one level. You could have it held by one person or multiple people. Those individuals would come from different parts of the world, may be engaged in different businesses, and they may have different issues surrounding them. So are they connected to high-risk business? In one of my past lives, I spoke about in the medical field, if a particular product that the company may be selling can be a dual-purpose goods. So it has a legitimate purpose, but nefarious actors can find something bad to do with it. You might want to scrutinize that more. And so you would know how to apply your due diligence. But then when you introduce complexity with multiple tiers, so you have levels upon levels upon levels, that is where you have some challenges. And then the percentage owned by different entities may not trigger due diligence checks in some jurisdictions. Interesting fact. But would in others. And one of my favorite examples, not picking on any jurisdiction in per se, but these are the jurisdictions that I'm familiar with. One of the examples is that with the UK Companies House, they have a publicly accessible register. But if you have a company that has 5 or more owners, they're natural persons, just for ease of reference, and they all equally hold shares in that company, you can have a nil filing for beneficial owners because their threshold is above 20%. So that same company would have to provide full beneficial ownership information to their regulated trust and corporate services provider and to other entities in the BVI or other Crown dependencies or other overseas territories. So Crown dependencies like Guernsey and Jersey are the ones that I'm very familiar with. So, those are some of the things that people looking from the outside might not be familiar with. And I think it's important for those things to be borne out because there's a lot of misinformation. And this is one of the things that I would like to go and dispel, get the misinformation out of the way. So beyond just what you look at in terms of ownership and what is required in one jurisdiction to another, compliance professionals that review those complex structures also have a challenge depending on where they are in the world. So where is your firm located? Is it complex enough yet? Probably not yet. If you add in now a publicly traded company or the business activities of certain corporate structures, which may be legal in one jurisdiction but not illegal in another, let's take medicinal marijuana, for example. If you have something like that in a structure, it can also present challenges as to whether this is business that beyond high risk, it might be illegal in the jurisdiction that you're in and you shouldn't even have it. And so the objective of a legal arrangement or legal structure is critical. When we look at legal arrangements, mostly trusts, foundations, AGs, and some other things that I won't even try to pronounce some of the European structures. You have a difference in terms of just the trust, purpose trust versus a discretionary trust versus an asset protection trust. Then you begin to see what may be keeping compliance professionals up at night. And I can understand why when I started to dive into this topic in terms of a review, why it may have been very topical for the discussion. But of course, that's just a quick overview as to what some of the issues are that we're looking at. So drilling down further, let's go now to the regulatory requirements. And what are the driving forces behind the development of regulatory requirements in any jurisdiction, particularly in jurisdiction jurisdictions that are under high scrutiny, disproportionately, in my view, to others. Although they say it's in level playing field, I have yet to see evidence of that. Of course, the biggest driver is the Financial Action Task Force, FATF, and the FATF recommendations that are applicable. Now, I'm not going to get into the minutia of recommendations 10, 12, 22, all of those different things. I am focusing on recommendations 24 and 25, which deals with legal structures and legal arrangements, respectively. And FATF has had a number of work streams on those issues. I've actually been fortunate enough to be at a plenary of 3 where they were at the discussion phase of beneficial ownership. Now, there are different groups under FATF that would look at different topics. And so for FATF, beneficial ownership would be was reviewed by the Policy Development Group, or PDG. Now, why is that important? You have different groups for different things, and sometimes you have cross-cutting issues where you could expose another work stream into bringing that into fruition. But policy development in of itself suggests a certain direction, and it's really live because FATF issued a statement just days ago. I think it was on the 4th of March. I have it in the description of this live already, but I'm going to touch on it more, and we'll go through some of the things that they've just amended in relation to recommendation 24. So if that's not live enough for you, I don't know what is. What else is there now? So FATF has gone through their review, and from my review, from my position, again, not reflecting any regulatory authority, these are all Simone's views. There was a disconnect as it relates to recommendation 24 and 25 in application on the law and in the mutual evaluation process when they reviewed countries for their compliance, technical compliance, and effectiveness under the FATF 4th round. One of the areas that I saw the disconnect, sometimes assessors are trained. I am actually also trained under the 4th round methodology. But if you come from a different jurisdiction, sometimes you have a different perspective than others, or a different appreciation, or more nuanced appreciation, to how certain things are dealt with in certain sectors of financial services. Now, the recent updates in relation to recommendation 24 says to me that the language supports the use of trust and corporate services providers as gatekeepers for beneficial ownership information, as opposed to publicly accessible register. The big takeaway here is that FATF seems to be projecting that once you are able to have up-to-date and accurate beneficial ownership information by whatever means, that's what you need to go with. And in past iterations and publications, there have been persons who have exposed the fallacy that public registers are a cure-all. Now, interestingly enough, what I found to be interesting two interestings, but a hot topic of discussion in the crypto community. And so I also do address crypto. If you're interested in seeing crypto compliance and the travel rule, I do have a YouTube video on that, but diving in a bit more, let me know in the comments. A hot discussion going on in the crypto community is on privacy that overlaps with the very topic of beneficial ownership. And so there's a lot being said about privacy when you do hold crypto. Yes, I do hold crypto. XRP is my biggest holding. I am shameless with that. I do hold other coins. Again, there's a video about that, but this is not what we're talking about. That topic is something that I'm definitely going to dive into in really granular detail in the Chasing Compliance membership in the coming weeks, because it's a live discussion. And I think that there can be some happy unions in terms of the ongoing discussions regarding beneficial ownership and the crypto community's discussions as it relates to privacy. Now, going back to the FATF recommendations, what happens is that countries will distill those recommendations and methodology into the local laws, right? And so this is how you get your regulatory requirements. And some jurisdictions will go beyond what FATF requires. That variance in adopting FATF recommendations and the methodology into local laws also adds to the complexity in terms of analyzing beneficial ownership structures, especially where arrangements have cross-jurisdictional reach. Now, if you are a compliance professional, I have a few areas that may help guide you in terms of the depth of your review. Public statements, that's number one. What public statements impact the jurisdiction in which a vehicle is formed or incorporated? Often you will have some jurisdictions that don't play as nicely with others. This is not a political channel. I will not be naming any of them. We will not be looking for brownie points for listing any current events. But certainly you have to have some awareness as to what public statements are relevant and applicable at the point of carrying out compliance measures. You also want to look at typology reports. Typology reports go even beyond FATF. There's Egmont, so that's the group of financial investigation units. And there are other bodies that put out relevant typology reports. Wolfsburg Group is another group that I don't think gets enough press, but they have put out a lot of publications that are very helpful. And if you can think on some of the other bodies, feel free to drop it in the description below. We're not going to have like a naming game for all of them right now during this live because there's a lot of content to get to. National risk assessment reports of relevant jurisdictions, particularly if they have been subject to an FATF mutual evaluation, you'd also want to look at the mutual evaluation report as it relates to immediate outcomes 2 and 3. What is your firm's individual risk tolerance? And then there's some other indices and reports that are published by other organizations that you could have a look at. And it's not to necessarily put one above the other, but to know that they're there. So you have, and again, you have to take it with the appropriate grains of salt or other minerals, the corruption index and transparency index. But of course, it's important to look at why these indices have been published and to what end are they and how independent are they? Do they have skewed perceptions in relation to certain jurisdictions over others? And those are just some of the things that I think are good points to look at. And if it is, you can think of any other areas. It's going to be a live discussion in the membership, but for not even a high level, that is a bit granular because we're talking about risk assessments and statements and actually doing your real investigation when you have a complex structure. It can help you in terms of what direction to look at as a compliance professional. Now, as it relates to AML, CFT compliance and risk management, I'm going to step back a bit from a direct focus on the companies and trusts and foundations and partnerships and other vehicles. And I think one of the things that I have championed in other forums is the regulation of trust and corporate services providers as a part of a more robust AML CFT framework. And I will immediately state that I'm biased. I've been working in an industry where they have been regulated for over 30 years. In some places it's going on 40 years, and there are other parts of the world that TCSPs are not regulated. And I'm sorry, the Treasury or certain other elements of a particular government's arm is not necessarily an AML regulator when they're looking at that. That is like an add-on to their mandate. Robust AML CFT regulation actually makes a difference in the quality of the beneficial ownership and other information that is captured by TCSPs. I personally think having a regulated TCSP that is responsible for conducting the KYC or customer due diligence, the risk assessment, and the other AML CFT requirements, that reporting to your FIUs or your engagement with other competent authorities, having that for entities that fall within the portfolio is a better approach than a register that is passive. They file the information and then they forget about it. Who has a carrot and stick formula to get at that information to make sure it's updated? Public registers seem to only have a stick, i.e. a fine if you don't update it, but who's really going to check and capture that? They can do it on a sample basis, of course, but that still leaves the probability there for things to fall through the crack. And then the TCSPs are in direct contact with the clients that can provide a better live feel and more qualitative data than the bare bones filing at a registry anyways. But that is just my personal view. Let me just get that out there. But regardless of what side you come down on, and if you feel like commenting negatively to say, yes, public registers are the best thing since sliced bread or since fire, that's you do you. But I have my views and I have data to support why I am so strong on those views. Both have their flaws. Both systems have their flaws. There are good and bad people everywhere. And working on fixing the flaws to eliminate the criminal activity should be the aim for any jurisdiction, regardless as to which model you take. Right here, I'd like to also mention a report that is not often cited, but evidences this very fact. The Puppet Master publication, a research piece that was done by the World Bank, was really telling. I think it was around 2013 where they did the mystery shopping around the world. And surprise, surprise, the offshore jurisdictions scored far better than a lot of G20 nations. And again, it put out the information from a very unbiased position as to which area had a better compliance position. And this was done before public registers were really a big thing. But I suspect work may be going on that front again. And the work that was also done by a professor, I think his name is Jason Sharman of Cambridge Judge Business School, was also quite noteworthy around this time. And he's contributed to a number of publications. Not a plug for Cambridge Judge Business School, but I thought it useful to mention these things because depending on how long you've been in the industry, you may not have heard of it. And some of these things are not as newsworthy as they should be. Offshore being good at what they do is not necessarily going to sell papers. Now, remember, I have to say this, these are my views and not the views of any organization or standard setting body before I get into trouble. Now, back to the TCSPs, regulated or unregulated. TCSPs may also provide certain services to clients, the vehicles, the trusts, the companies. They may manage or administer them. And in other cases, they may not. But where they're providing a fiduciary duty, guess what? You're likely to have better beneficial ownership information than not. Now, whether a TCSP is regulated or not, once they act in that fiduciary capacity, they should definitely have their ducks in a better row for beneficial ownership on vehicles. And more live application of risk assessment and monitoring and other things that are important to a good compliance framework. So not telling you to dive deeply into providing certain management services, but it's something that you may want to think about. So what else is there? Let's see. So as you add complexity, the application of compliance measures can become a lot more challenging. And I've actually had the fortunate experience of facilitating compliance classes for a particular accredited, certificate diploma compliance group. And in those particular classes, I have given a case study example that challenged all of the participants on how complex it can be to get your due diligence right just from the business activity standpoint alone. And that case study is a company that has disclosed its business as owning real estate. And I would continue to ask questions. So layer on the questions. Where is the real estate located? What type of land is it? How are you asking the right questions in relation to that? And the company could be in a vanilla jurisdiction owning commercial property, but then all of a sudden gets into a sanctioned countries holding land that has rare earth minerals, and the game has changed within days or months of you acquiring that first element of due diligence. However, keeping in line with that, the different variables that could occur in a multi-tiered ownership structure are compounded by the levels of ownership. And the probing questions that compliance professionals do ask and have answered are only for one point in time. The simple structures, vanilla structures, is relatively simple to keep on top of ownership. And it's not to say that complexity is bad, but you can easily have an issue with ownership and knowing who owns what and controls what when something changes, whether through an acquisition or merger, and someone forgot to advise the relevant persons. And that includes public registers. So, it's important to keep on top of that information. Now, one approach while I was preparing this, and I did a quick check, but I didn't really dive into depth in this. So let me put that disclaimer out. One approach that I thought about, if I was in the seat of a compliance officer, what would I do to address this? And an approach could be a bifurcated risk assessment, where you have different risk weights at different levels of ownership. I have not personally seen it done. I don't know if it has been done. I don't know if any service provider out there does it, but it sits logically in my mind because intuitively, many compliance professionals have to have a sense of whether they should look at one particular branch of the ownership. So something that's going over here in relation to the complexity or jurisdictions or the type of structure, and what areas or parts of the ownership structure that may trigger the most concern. And that's where I came up with a bifurcated risk assessment. So you could have something that has some vanilla ownership, and then because of an acquisition, you have something that's a little more hairy and tentacles, and basically a chimera. And you want to sleep better at night, possibly having a bifurcated risk assessment framework for your ownership is one of the ways to go. Just a thought. It could work. It might not. Feel free to comment. Now, we could move on to sanctions compliance. And a lot is going on in the world right now. And taking all of what is happening, I hope it's clearer for persons to recognize how challenging ensuring compliance is, much less sanctions compliance, whether from OFAC and that's an organization in the US, UN, EU, or other relevant sovereign countries or supranational organizations. Sanctions compliance can be complex. There's no two bones about it. And a little tidbit for my colleagues here in the Virgin Islands, the British Virgin Islands. Some persons might wonder, well, why is it that I need to have regard to US sanctions? The US dollar, we're a dollarized country, and many countries are dollarized countries. So we don't have our own official currency. It is one of the things that nations would need to address their mind towards for other purposes, maybe independence, calculating your GDP, certain economic indicators towards that end. But if you're dollarized, the tap can be closed off pretty quickly if you have just a free-for-all for sanctioned individuals. So that's why it's important to have OFAC in there. But what complex structures can and often do is obscure precisely who may be subject to sanctions or an entity. And that may go undetected because you've not given sufficient attention to your complex structures. And at this point, I would like to state something that I may not have made clear earlier. If a structure is complex without there being a clear and logical reason for the complexity, because there are cases that do exist, you should not take on the business as a trust and corporate services provider, because there are several questions that may come up. How do you test it? How do you actually comfort yourself that there is not a hydra in there waiting to just ruin your firm, your reputation, everything you've come to know and love about, financial services for you, your jurisdiction? Another question: can you explain your position on this particular complex structure to law enforcement agencies? And were you complicit or knowingly aiding sanctions busting? One other point of concern that tends to crop up in complex structures that I've seen is the creation of these complex structures by lawyers holding themselves out as being outside of the scope of AML/CFT regulation. Now, this is not to vilify lawyers at all. One of the things with the legal fraternity, I would say, is that it's important to note that there are lawyers all over. There are compliance officers who are lawyers, there are regulators who are lawyers. They are good and bad people everywhere, including lawyers, including regulators. People are just good or bad, point blank. That's how I see it. And one of the things that I have often questioned as a regulator, looking at a form when I'm doing an inspection, maybe it hasn't come up in terms of that particular element recently because I've not gone out and done inspections for quite some time. And guess what? You might have a complex structure sitting in your portfolio that was created by a lawyer. Do you have a legal opinion supporting why this complexity is needed? As the young people would say, these are questions that need answers. So I think that that is something you might want to have a look at. Now, before I continue with the rest of the discussion, let me provide a bit of information on the membership because you've heard me mention things that are going to be available exclusively to my members. There is a membership platform that I've created that's just for compliance professionals, and it's called Chasing Compliance. Now, compliance professionals have some of the most demanding jobs. And the trend is already obvious that that is set to continue. Ain't nothing changing about the complexity of your job. One of the things that I'm aiming to do is have a space for, well, several things to continue the discussions that we have in a public space that is safe for you to ask questions, engage, and get insight from other professionals. There'll also be guest speakers there. There'll be discounts offered for certain items that are offered by Ignis Solutions Limited now and in the future. And now we're going to have content that's going to be attached. I think one of the things that I've worked on is a checklist. It may be in the link to this video within 24 hours. So definitely check back and share it with people who you think might be interested. Things to help you as a compliance professional. And that means you get to basically get some information quicker than it takes you to actually review a compliance manual. There are limited spaces. I'm not trying to like solve the planet, but I'm looking forward to welcoming. I still have the founding members bit open. And so there are details provided in the description below. And so with that being said, I can move on to the next area. And I've not been so good in looking at, all right, no comments thus far, but that's fine. I can welcome comments afterwards. Taxation. Now, many persons think that corporates look for offshore centers to avoid paying taxes. No, I will ignore a certain multinational beverage company, hot beverage, that made the news a few years ago on this very topic. And there are another few companies that do this, really large ones, but not touching on that. Reducing the taxes of any person, natural, so people or legal persons, is not illegal. Let's get that out of the way. It does trigger a lot of discussions by many different groups on the point to social good that tax revenues can help with and what they can be applied to. And there are other points of discussions. Well, those revenues are not spent in the best way. And my expertise does not extend to taxation. I will be the first to admit. However, from my regulatory experiences, I've seen some things where it is clear that structures are developed for the purposes of having neutrality between parties from different jurisdictions. So you might get a company in a jurisdiction such as the BVI, where you're seeking to engage with partners from different parts of the world because you want the certainty of the British legal system. It has nothing to do with the fact that we are a series of small islands and regulation does not happen on the beach. And I can definitely tell you that from experience is a heavy lift for small jurisdictions. And oftentimes standing next to my peers from G20 countries, which I've been fortunate to have the opportunity to do, we do measure up. So, if you're a regulator in one of those jurisdictions, don't ever feel that you are less than, because we do have a heavy lift. And from my engagement, we've seen it's not something that we would go out and look for, but say in an inspection or something, or discussions or collaborations across jurisdictions, that these structures, many of these structures are not created to evade taxes. So I'll say that and leave that there. I've seen that this is often a political touchstone, and we don't cover politics on this channel. So, as it relates to compliance, it is important to review the complex structures to drill down and assess whether tax evasion may be occurring, because tax evasion is a predicate offense, which means it's a financial crime, which means you would have a problem if that is going on through a complex structure. Now, moving on to other issues and implications. Let me go back to FATF's recent work in relation to Recommendation 24. And I'm going to read from a bit that they've put out here in relation to that. And one of the things that they said is that finally, the changes to include stronger controls to prevent the misuse of bearer shares, nominee arrangements, including the prohibiting the issuance of new bearer shares and bearer warrants, and conversion or immobilization of the existing ones, and more robust transparency requirements for nominee arrangements. And I found that to be incredibly interesting because it highlights just how live the issues are. The public statement was issued on the 4th of March. This is being recorded on the 7th of March, 2022. And so it is a live topic for standard setters. And so live that I was actually preparing my notes in relation to this prior to this public statement coming out. Now, and the first issue that I had in relation to your complex structures was the use of bearer shares, bearer warrants, and similar instruments. And what I have seen over my experience is that they've been great. The use of them has been reduced significantly. And where they exist, they're well immobilized. And so it has the effect of a registered share. But you might be wondering, well, why do we even need to have bearer shares? Separate discussion. If you want a separate YouTube video on that, I'd be happy to do it. But in some jurisdictions, you may be familiar. If people know that you're rich, you and your children and your family become targets of corruption and kidnapping and all sorts of other things. And in cases where it's found out, I've heard from some of my law enforcement colleagues where it is tragic how it ends. So there are reasons why they exist. But if your inquiries into a complex structure as a compliance professional does not explicitly seek to confirm whether there are bearer shares, immobilized or not, or similar instruments in that ownership structure, your compliance efforts might be just in vain. Let me just let you know that right there, right now. What else is there? So, reliance on third parties, also known as introducers in some jurisdictions. This is captured and permitted by FATF Recommendation 17. And there would be laws in your jurisdiction that are specific to this. But it adds a potential risk to service providers and competent authorities, actually, from being able to access and obtain that beneficial ownership information in a timely manner. Now, the changes to Recommendation 17 were, because they were 2012, they were designed to help address some of the challenges that we're seeing. And I've given the story in maybe a conference or something where there was an entity, it was introduced, it was connected to a mafia from a particular country we won't be naming today, and it was introduced business. And, there was a lot of vilifying of the offshore jurisdiction, but it was later realized that the introducer was married to the sister of one of the mafia. How accurate do you think his information would be in terms of what he's providing to the service provider? So, in my view, is essential. Well, it's actually required, but in some jurisdictions, they might not fully apply the FATF provisions. But it is essential to risk assess and review any third parties that may be used directly by your firm or known to exist within a complex structure. And based on the risks, there's that word again, it should attract additional scrutiny. So it may not be always apparent that maybe a third party or another person might be acting as a fiduciary, but if you get your hands on those registers, so the register of directors especially, and sometimes the register of members may give you a clue to the fact that third parties are involved. Another area that I've seen where issues pop up and they kind of fall below the radar is the use of general powers of attorney. And they may be used within corporate structures and go undetected. Now, while there are legitimate uses for power of attorney, the due diligence may not always reveal the fact that they exist. And if they exist, especially the general ones, the due diligence that you conduct on that corporate entity is useless because someone else is controlling that company. Someone may own the company, but there is another person and they might be a director, but there may be someone else that is undetected who actually exercises true control over the structure. And that might be shocking to some persons. Hey, it happens. I've seen it. And it's important to make sure that you're aware of it. Quiet tonight, nothing on the chat. I was looking for comments on some of these issues, but feel free to comment after, like I said, or just shoot me up something on LinkedIn. It's in the description of the videos past, and I'll update the description to make sure that there are ways to get to me. So after the power of attorneys, there's something that I have had heated discussions with other persons, including international standard setters, about the use of the word nominee in front of the word director. There is no such thing, at least under common law. I'm not a lawyer. I know enough company law to know that nominee directors are not a thing. Directors have a legally enforceable set of fiduciary duties. Now, what I will say is that criminals and bad actors do use straw men to conceal who are the people who truly control a legal structure. And it's important for that to be identified, while you are reviewing your complex structures. It's also important to recognize that in some jurisdictions, persons may not understand this, that like being a director is a real thing and that it comes with real responsibilities and that you could be on the hook for real consequences, especially for gross negligence and all of that. But if you have an entity within your ownership structure where you have concerns that they may just be appointing a person, I used to use a real, not a real example, but a real name, a very common name in a different language, who maybe, and just fill in the blank, John Doe, and it wasn't John Doe, is a farmer out in rural fill in blank country. But that country has lots of corruption, but the farmer has billions of dollars flowing through. And yes, food security is important, but that is not the scale of his operations. And simple due diligence would show you that this is a straw man that has been asked or paid maybe $100 in whatever currency to provide his name and his identification documents so that bad actors can skirt around all of the due diligence information. So these are the things that you need to think about. Now, other issues, competent authorities do require beneficial ownership information from time to time for international cooperation purposes. And this bleeds into recommendations 36 through 40, very relevant if you're a regulatory authority, an FIU, tax authority, law enforcement. And why? Because, hey, people use structures for bad things. And I really have a personal grouse about the jurisdiction where I'm from, the British Virgin Islands, being targeted as one of these bad jurisdictions. We're popular for a reason, but I'm not here to get into marketing. But if you have a bad actor that uses an iPhone or Samsung or pick your device to call in and, do something of terrorist nature, I don't want any copyright, any strikes from YouTube. Nobody is going to go and say down with Apple or down with Samsung. They're not going to do that. Why would they even do that? They're using something that is popular for that thing. It's not the vehicle that is good or bad. It is the people behind it. And of course, you don't want anything that is from your jurisdiction or from your company being used for bad purposes. But this is the nature of the world. And if you're going to hide, you don't necessarily hide where it's sparsely populated. You hide where you have a crowd to hide it. But those are just my views. And when you look at it percentage wise, you know, again, or even perception wise, if there's a fraud that's conducted in, say, a particular G7 country, and let's go to G6, let's take out one, you could figure out which one I'm taking out, a G6 country, and the fraud is of, say, $10 million, that doesn't even make page 16 of the New York Times. But if you have the same issue happening in one of these jurisdictions, it is front page news and we don't know what we're doing. Never mind that even that amount of money moving through our banking system would throw up its own flags, but I'll stop the rant there. It's just one of the issues where there's a lot of misinformation around. And I spoke about that in one of my past YouTube videos. But back to competent authorities and their need for beneficial ownership information. Your records, compliance people, your records and your record retention policies should be also assessed to ensure that you have that information for as long as you need to have it. Now, one of the things that I've seen that has caught some firms out in certain jurisdictions when I'm reading case studies provided from different countries is that there is a disconnect in terms of when you start aging records. So when do you need to, when do you get to the 5 years that is prescribed by FATF or longer in your jurisdiction? That could leave a firm exposed because there are many firms that think that, well, the company is struck or I haven't heard from them on this and they haven't paid their fees, so I'll just start the account then. Bad actors don't care whether the company is in good standing, one. And two, a passive act doesn't necessarily mean that you've terminated the relationship. So things like dissolution or the business is being transferred out of your portfolio completely, things like that are nice, firm, clean lines in the sand that help you to determine your record retention policy. So now, one of the last things that I wanted to touch on is the issue of definitions. I keep seeing shell companies being thrown about, and who makes the definitions? Who gets to contribute to these definitions? And it's a point I raised in a different place, much to the chagrin of persons. And so the definitions that need to be developed, I think, by jurisdictions that have really experience and real depth in this space. I'm personally always happy to continue the discussion. And I think that the definitions of things like shell companies, shelf companies, age companies, dormant companies, all those things would actually go a long way to help start unpicking some of the misinformation that is put out there. Because guess what? When people are going to make an argument, and lawyers, you can back me up on this one, you go back to the definition of that thing. What does the definition say? What does it mean? What is the spirit and intent behind this thing? So it's important for us to define what we're talking about in relation to a number of topics. And that's an area that is going to be explored in the membership, because I might have some views that might be a little too controversial for YouTube. And so, one of the things that I would want to just say just before I wrap up, you want to get clarity on a number of regulatory issues that impact you, or compliance issues. Might not be even direct regulation, but just compliance issues. Complexity in the beneficial ownership discussion is very live, as you've seen from FATF and their recent publication. No two jurisdictions are alike, but guess what? Their financial services regulation is built from the same stuff, international standards. And if you have questions, I'd be happy to have them, bring them. If you think I can answer them all, no. I don't know everything. But in this setting, and I think even more so in the membership, there's a higher probability of us getting to that fabled regulatory clarity. If there's a topic you wish to see in a future live event, crypto compliance, travel rule, anything like that, or even just more of the topics that surround offshore, international cooperation, you let me know in the comments. And what I definitely look forward to is the engagement. And I want to thank everybody for stopping by. I see, I've had good turnout for my lives. Share this because it'll definitely be up afterwards. And I would encourage everyone to check out my membership. There is a cost attached to it, but there are lots of benefits and lots of things that I will be more at liberty to see. And members, for the members that are in the group right now, the Chasing Compliance group, the notes, my fuller notes and some expanded comments will be provided to you in the coming days with all the links and supplemental info. Now, for those who are not members, I want to make sure that I give that value. There will also be information provided as a free downloadable for you. It won't be the full kit and caboodle, but look out for that. There'll also be links to downloadable resources, paid and not paid, for compliance professionals, because membership does have its benefits. And there will be discounts, deep discounts for members, just for members. So I would want to end and say, don't forget to like this video if you found the content interesting. Make sure you share it with others and subscribe if you haven't. Please subscribe. I'm definitely back. I'm working on recording some content. I'm seeing questions jumping in the last minute. Crypto compliance, please, definitely. We'll work on that. And do you think it's fine to no longer cover that KYC unauthorized persons for regulated entities? Depends. And with compliance, sometimes it's not a straightforward answer, but that particular element is something that feel free to provide me another comment or DM me in LinkedIn. My LinkedIn details are in other video descriptions. And I'll be happy to have that discussion because, again, it depends on the jurisdiction and where you're at and some of the variables and the risk assessment. So happy to help you navigate some of those issues. And yeah, I think this was great. And I kept it to about an hour. So guys, thank you all for tuning in. For all of you that stuck with me during the live, I hope you found this insightful, and welcome to my home. I'm finally back home without tech support. But I think I managed quite well tonight, and I look forward to catching you on the next one. So until my next one, guys, I'll see you soon.